All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Good morning. Welcome to the Kansas Supreme Court. We look forward to the arguments of the council today. For those who may be watching by our live stream, I do want to just make some preliminary remarks to kind of explain the process of how the court functions in terms of being prepared for today. We do have written or arguments in the form of briefs from the attorneys, as well as the record that was developed at the trial court level about the proceedings that bring us to that caused the appeal. And so the court is familiar with those written arguments as well as those portions of the record that may be relevant to the arguments. But we look forward today to having an exchange with the attorneys to probe deeper into those arguments and to improve our understanding of the points the attorneys are making. With that, I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 a.m. docket.
Thank you, Hambright. Please the court. The first case on the 9 a.m. docket for Thursday, December 14th, 2023 is appeal number 124626, State of Kansas versus Brian Curtis Daniels Jr., Sedgwick County, briefs both sides.
May it please the court, Mr. Daniels appears through his counsel, Hope Faflick Reynolds of the Kansas Appellate Defender Office. Present and ready for argument.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Second case is appeal number 124878, State of Kansas versus Gerald D. Hambright, Sedgwick County, briefs both sides.
May it please the court, Assistant District Attorney Matt Maloney for the state. Chief Justice, if I could please reserve 3 minutes of rebuttal.
3 minutes granted.
Thank you.
May it please the court, Gerald Hambright appears through counsel, Casper Shire, Kansas Appellate Defender, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. That I would ask the counsel in 124626, State of Kansas versus Brian Curtis Daniels Jr. to come forward. While they do so, I will explain also that the court does have notes before it, some of us on computer, some on paper. You will see us frequently looking at those notes or making additional notes. I just want to assure the parties, counsel, and those who are watching that as we do so, we are still attentively listening. Those are just processes that help us assimilate the arguments. So that, Ms. Reynolds.
May it please the court, Hope Faflick Reynolds appearing on behalf of Mr. Daniels. Chief Justice Lukert, may I please reserve 5 minutes of rebuttal?
5 minutes is reserved.
Thank you. This case presents a single issue, which is how Mr. Daniels' prior conviction for burglary in Georgia should affect his criminal history.
Yeah.
Or we'll just pause. We'll just pause your time and sorry for the interruption. Hopefully you don't lose your chain of thought. I would if it were me, I imagine.
Sorry, Chief.
No problem. Yeah, no, thank you. And I apologize for the interruption, but this gives us a good sound quality for future use of the argument. So thank you.
Is this working now? Okay. Thank you, Chief Justice. This court's holding in Bush and the plain text of the Kansas sentencing statute require us to look at the elements of the Georgia burglary conviction, not the facts or the circumstances surrounding the conviction. The word circumstances is used in the statute, but only regarding the list. The relevant portion of which we're talking about is subsection G, habitat, dwelling, or residence. That's not the way in which we evaluate prior out-of-state sentencing. We look at the elements, which was, again, on the text of the statute in subsection I and I, which this court interpreted in Bush. The other reason that we do that is really important is because it avoids a thicket of constitutional issues with judicial fact-finding at sentencing. It's clear that when the legislature redid the sentencing scheme to enact the statute, they were hoping to avoid those constitutional problems. It's also clear that the type of work the state is asking Mr. Daniels to do is not how the statute's written. The state in its supplemental brief expects Mr. Daniels to produce journal entries about the facts of how he was charged with burglary in Georgia.
Well,
That's-
I'm gonna push back on that just a little bit. And let's back up to the sentencing hearing itself.
Mhm.
This statute, under the conviction code, has 3 letters, 3 designations.
Mhm.
A stands for adult, F stands for felony, and P stands for person. So in Corby, it was established that that the classification was also admitted by the defendant when he said, yes, I admit to the criminal history. In Corby, however, the difference between a felony and a misdemeanor designation determined the result because the misdemeanor was non-person. All of the felonies under that statute were person felonies. But the P stands for person. Now, we have case law to indicate pretty clearly that the person designation is a conclusion of law to be made by the court in this very case. So what is the effect of the defendant's answer to the judge's question, do you admit criminal history?
Yeah, so that is on page 2 of volume 4, which is the sentencing hearing. And the district court judge asks Mr. Daniels, do you agree to this criminal history? And he says, yes. The plea agreement that they were basing that on also in subsection 14, which is page 26 through 28 of volume 1 of the record, specifically preserves his right to challenge his criminal history on appeal. As to your honor's question about the effect of Corby on this case, I think that Corby is different for several reasons. First, Corby dealt with prior in-state crimes. In Kansas, fleeing and eluding can be a felony or a misdemeanor. And this court said in Corby that when somebody agrees in district court, I was convicted of felony, fleeing and eluding in Kansas, they cannot then say the state didn't prove that on appeal. Corby is about the burden of proof. Corby is not about what it takes to show the burden. Corby just argued that the state didn't meet its burden and didn't say this is incorrect. This case is different. Yes, Your Honor.
Okay, go ahead.
Well, this case is different because there's no world in which the elements of the Georgia statute require a circumstance listed in the Kansas statute. It's not a factual question of was he convicted of this type of Georgia burglary or this other type of Georgia burglary. the statute says, the Kansas sentencing statute says, we look at the elements of the prior out-of-state conviction and we see, do they necessarily include any of these circumstances in the Kansas statute? And they don't. There is no world in which the Georgia elements require, as this court has interpreted that word, one of the circumstances in the Kansas statute. And that is why, even if it is Mr. Daniels' burden to show his criminal history is incorrect, he can do that just on the face of the statutes, which are written to operate as a matter of law and as a legal conclusion, not as a factual inquiry, which is where we get those problems.
Well, can Mr. Daniels admit to a conclusion of law?
I don't think so, Your Honor. This is also, I would understand a different case, that's not this one, if he made a different argument in district court, like an invited error issue, and this court has case law with precluding parties from switching legal arguments midway through a case. But that's not what happened here. Here, he agreed he had a prior Georgia conviction, and the issue is, how should Kansas law treat that conviction at sentencing?
Let me ask you a question. And, I think something is going over my head because I don't understand it. When you look at the Georgia law, it says you commit burglary when, with or without authority, with intent to commit a felony within, you enter or remain within a dwelling house of of any building, dwelling house of another, or any building, vehicle, blah, 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 that's used as a dwelling. And then, so that's kind of the dwelling part of it, or enters or remains within any other building, railroad, blah, blah, blah. But that fits B little I H, entering or remaining within any dwelling.
Yeah, so Your Honor is correct that the word dwelling is present in the Georgia statute, but the statute goes on to designate other forms for burglary under Georgia law. And those include a vehicle, a rail car, a watercraft, or any other structure designed for use of the dwelling of another. So that means that Georgia law does not require proof of entering or remaining within a dwelling, habitat, or structure as listed in the Kansas circumstance.
Are you saying that there's no way the state could have met a burden to show that the Georgia conviction would qualify as a person felony and go forward? I mean, it's just impossible. Doesn't matter what this guy says. It is literally impossible.
That's what I don't get.
I think that the way the legislature wrote the sentencing law, because it's based on the elements of the out-of-state jurisdiction, under that law, there is no world in which the state can prove a Georgia burglary counts as a person felony because its elements do not require.
I thought that the burden of proof we were discussing is not any burglary, but rather this burglary.
Right.
So why couldn't the state prove that this burglary is comparable?
I think that they could try, but in this case, they didn't. And the issue
Oh,
is,
but that gets back to the whole burden of proof question. I mean, I do understand, at least I think I understand your argument being, yes, the statute may put the burden of proof on us, but we don't actually have to demonstrate any facts because we win on the law.
right.
But if you don't actually win on the law, then are we stuck with state's argument, as I understand it, which is there are facts out there that matter, and it's not our burden to come forward with those facts.
I don't think so, because I think that contravenes the plain text of the Kansas sentencing statute, which requires us to look at the elements. I also think that the way the Georgia statute is written, each of those forums are in one subsection. And that mattered to this court when it decided Bush, where the prior burglary conviction was a non-person felony, the New Jersey burglary conviction, but the criminal trespass conviction was okay to count as a person felony because of the divisibility of the statute, which is a difference here.
So you're arguing that just because the Georgia statute by its elements is broader than the Kansas statute. As a matter of law, it can never be comparable, even if the facts of the case fit the Kansas statute.
Yes, Your Honor.
Well, in.
That's under subsection. Sorry, Justice Wilson. That's argument really hinges on the little 3 and the language there that if it's not required to prove the elements of a residential burglary, because there are maybe alternative means of committing that crime, that's the matter of law argument you're making. So the factual question really is moot. If is that your argument?
Yes, Your Honor.
Okay.
But what about the word any? Do not require proof of any of the circumstances. Oh, it's just, sorry, Justice Wilson, go ahead.
Well, in Bush, that on the criminal trespass, that also turned on whether it was a felony or a misdemeanor, didn't it? Because he admitted the criminal history, including that it was a felony, and the only felony in the divisible criminal trespass statute was a person felony, required that it be done in a residence, correct?
That's my understanding of the New Jersey criminal trespass statute, yes.
So the only thing that the court needed to, information the court needed to make the decision in Bush was that it was a felony, because then it necessarily did include a residence, correct?
Yes, Your Honor.
Now, going back to the criminal history, is there any other significance, factual significance, that can be inferred by the court in making a conclusion of law on whether it's person or non-person from Daniel's blanketed agreement to the criminal history?
I'm going to see if I understand your question. Are you asking what the significance of the stipulation is regarding the legal classification of the conviction?
What is the significance, the fact significance of the blanket admission by Mr. Daniels that he agrees with the criminal history as questioned by the court?
So he's barred from challenging the existence of that conviction in the future. He is barred from, or at least carries the burden of demonstrating if there's some defect in which portion of the statute he's convicted under, because it lists the statute and then it has that AFP designation that Your Honor mentioned. But as far as the legal classification, I think that under this court's law, he is unable to agree to an illegal sentence and is therefore free to challenge his sentence as illegal, which is different than Corby because he only might have agreed to an illegal sentence. Here, it's clear he did as a matter of law, which this court has long prohibited. I see my time has expired, Chief Justice. I'll be back for rebuttal. Thank you.
Thank you.
Good morning, Your Honors. May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. From the state's position, the resolution of this case is actually fairly straightforward, although along the path, we are asking for a little bit of help in helping to understand Bush and exactly how it is to be applied going forward. The first point that is absolutely clear is that under 2168-14 subsection C, the burden is now definitively upon the defendant to demonstrate the illegality of his sentence by challenging his criminal history.
Is there any indication, any underlying facts, testimony, basis for the court's legal conclusion that this was a person felony, other than the P designation and PSI report and the admission?
The statute says that the defendant's admission alone and along with that pre-sentence investigation are sufficient.
So we would have to presume that he was also admitting to the P in addition to the F and the A and the existence of a conviction, correct?
Correct. I think that's what that admission means.
But you agree the P designation is a legal conclusion.
Yes,
Is the defendant qualified to make a legal conclusion the court is also charged to make in this very case?
with the advice of counsel, I mean, individuals are charged with knowing the law, number one. Number two, he is acting here with the advice of counsel who also admitted and agreed to the criminal history score.
That doesn't really answer my question. Is he qualified to make a legal conclusion, which P is? And our case law is very clear on that.
I mean, respectfully, I think that the answer has to be yes. When he's doing something, he knows his criminal history as better, if not better
No,
than
but he,
anyone else.
you know, I hear that argument all the time from the
Sure.
state. Defendants know their criminal history. When we can't figure out what the classification, yes, they may know what crimes they've committed, but even that, if you go back 5, 10 years and you have a list here, maybe they know, maybe they don't know. At least was my experience with handling sentencings. But if we can't figure out what the classification is, how can someone sitting there say, yeah, my Georgia conviction is a person felony?
I mean,
How does that work? You can't be serious to say that that's a legal conclusion that they can stipulate to and they can understand.
I'm quite serious. The only question here is whether that Georgia prior occurred in a dwelling. That's the only question that makes it person or non-person. That's not a complicated question at all.
Well,
Where did I burgle?
Does that violate Apprendi then?
No, it does
Right.
not, based on this court's prior case law and started with Dickey, Wettrich, Murdoch, that whole line of case law back then. What we're talking about here is divining the elements of the prior offense.
No, what I'm asking is, does it violate Apprendi for the court to ask a defendant to make an admission that enhances his criminal history?
I don't believe that it would. I also don't know that, I don't believe that question is before this court respectfully in this particular brief, but I don't believe that it would because we're not talking about a factual finding.
Well, in your supplemental brief, you mentioned the few documents that under day camp that the court can consider under the modified categorical approach in enhancing a defendant's criminal history. And one of them isn't a PSI report, at least not that I've seen or that's been decided, and certainly not the ability to ask a defendant to make an admission.
The court has the duty to inquire. The defendant doesn't have to admit. He can challenge that PSI, and it is that challenge at the time of sentencing, at which point we could then progress and apply. I believe we can still apply the modified categorical approach post-Bush. Even it appears that is the status of the law.
Can the P be interpreted to be anything other than a conclusion of law?
I don't believe
In the PSI report, the P designation of person felony, can that be considered by this court as anything other than a conclusion of law?
In this case, no. Can I imagine another case where, I mean, I think we dealt with that a little bit in the Dickey cases where we were talking about start delving into having to make factual findings to support or to determine that question, then we could run into a problem. But here we're not talking about any kind of a factual finding to support the P person felony classification.
Well,
It is a
but
question of law.
doesn't it have to be a factual finding in order for it to be evidence
No.
for the court to consider? I mean, you're asking the court to make a conclusion of law in this case based on someone else's conclusion of law in the same case, right? Unless you can designate the P as something other than a conclusion of law made by the defendant. Can it be considered as
I'm not sure.
evidence?
I'm not sure I'm understanding the question because the PSI presumptively satisfies whatever the state's burden of proof is. I think it's well understood that we cannot engage in fact finding contrary to Apprendi here, but this court's precedents are replete with examples of the fact that a person designation is a question of law. And I think that 216811, the subsections that we're talking about here, they simply explain how that question of law is answered. The PSI, the admission, that all supports it. And if defendant would like to now later challenge it, that burden is on him. And the statute also 2168-14D as of 2022 gives him a way to factually challenge, to now say, look, I made this admission, it was wrong.
Counsel, I
As a matter of
understand the
law.
whole argument to be, yes, I'm challenging the conclusion that this is a person felony as a matter of law, and I'm challenging it on the law. And it just seems like your argument begs the question. I'm not saying you're wrong, but you're not addressing, it's like ships passing in the night here.
And I think frankly it is, because I don't think that the defendant's argument tracks the law under Kansas.
Well,
under
why are they
Kansas
wrong?
law.
Why are they wrong?
Because in Georgia, whether or not a burglary occurred at a dwelling, and this is not refuted by the defense at all, is a question of law. It has to be alleged and proven in that prior case. Georgia burglary is a divisible crime that not only does the dwelling have to be alleged, it must then be proved in order to support it.
Help me out a little bit here. Guess I want to rewind to, I mean, let's assume the defendant doesn't stipulate. What do you have to prove in order to get this classification for this Georgia offense?
We would have to demonstrate that as a matter of law, the elements of defendant's specific prior conviction, not just the Georgia statute in general, that his prior offense.
How do you do that?
PSI would be step one. Step two would be if there is a challenge, assuming there's a challenge, to provide documentation that would support the conclusion as a matter of law that the prior occurred at a dwelling.
Would have to show that the Georgia burglary occurred in a dwelling as opposed to an airplane hangar, for example.
Assuming the airplane hangar doesn't also have an apartment inside, yes. Yeah. We would have to do that if that challenge is made at sentencing, correct. And so the coin is just flipped now. That burden is upon defendant to demonstrate that as a matter of law.
I'd
It's
like to
possible
explore
to-
the stipulation a little bit. My understanding is he was asked if he agreed to the criminal history. When I look at the definition of criminal history in KSA 216803, it seems to me that that definition is just about the historical fact that there was a conviction under a specific statute and nothing more. We have a different term defined as a criminal history score that does then seem to get into the way in which we score that on the matrix, on the grid. And especially here where the plea agreement reserved a right to appeal and question the criminal history score. Can we say this defendant did stipulate to this being a person felony?
My answer would be, there's no reason why not. And the second thing I would say is defendant has not made any kind of a claim that his admission was not sufficient under 6803 that Your Honor is now quoting. I would also note that the existence of a prior conviction would necessarily encompass the elements that as a matter of law are required to establish that prior conviction. So I don't think there is a substantive difference here at all.
There is sort of a maxim, I guess is maybe the right word to use in the law, that parties can't stipulate to the law. They can stipulate to facts. And aren't we here talking about a stipulation to a legal conclusion?
I think we're talking about a stipulation to a legal conclusion that is based on established facts. We're not reevaluating any facts here. These things have already been established. They are unquestionably now matters of law. That's what we're really talking about.
Can you help me understand this, your statutory interpretation of 216811 E3B little III, or at least how you would refute your opposing counsel's construction that it really doesn't even matter, because when you have, I don't know, you called it a divisible statute or several different means of committing an offense, that language that if the elements of the offense do not require proof of any of the circumstances above, then it's a non-person felony.
Because under Georgia, when that law being divisible, a prosecutor from the very beginning is required to allege as an element the location of the prior crime. That is included in my brief.
But I think as I understand it, their argument is that in our state, the legislature has decided in circumstances when another state defines an offense to include these alternative means that don't necessarily in every case require a residential burglary, then we're just, as a matter of policy, going to deem those offenses as non-person offenses based on that language.
And my response to that would be, I guess it would be twofold, and it would be starting with subsection B, little I, and we're talking about in designating a felony crime, the felony crime shall be classified. We're talking about a specific felony crime. We're not talking about generally, and I don't believe generally that an out-of-state statute broadly, and that's where I'm not frankly 100% certain that the Court of Appeals got this exactly correct. We are talking about a specific prior offense, and the subsection that Your Honors asked about as well talks about specifically an out-of-state conviction or adjudication. If the elements of the offense, we're talking about defendant-specific offense. We're not talking just blindly about a statute. We still have the modified categorical approach available to us, is my understanding following Bush. And I'll just, to highlight that, the ultimate problem in Bush was that I believe, even employing that approach, there was no way to determine that a New Jersey burglary contained a dwelling, because unlike Georgia, that's not strictly required as an element. It can't be strictly required as an element.
But that's the floor designation, isn't it? The modified categorical or categorical approach, the constitutional floor. Our legislature has the right to broaden that or make it even less restrictive on the defendant by saying what Justice Wall indicated. As a matter of policy, if it's divisible, it's going to be non-person. Case closed. That's how we're going to score in Kansas for Kansas sentencing purposes, that conviction.
I suppose it's possible for the legislature to rewrite the statute again to say that, but that's not what they've said with 216811 and the quote unquote Wetridge fix. That's just not what they said. They haven't.
Well, the defendant asserts that they did. They said, number one, the statute has to have one of these circumstances present, which the Georgia statute does, but one of those circumstances must be required for conviction.
And I'm explaining to that defendant's prior conviction in almost certainly did require the element of a dwelling. And the burden is on him, based on his prior admissions, to demonstrate that it did not occur at a dwelling. I have no burden before this court today.
Isn't the almost certainly in your answer? It just opens the door to facts.
No, it opens the door to defendant trying to meet his burden to demonstrate that as a matter of law, his prior conviction did not occur.
The problem, I think, or at least maybe the problem is almost certainly doesn't show up in the statute. Statute is, as I think Justice Wilson was pointing out, definitive. It doesn't give you the wiggle room.
I don't need the wiggle room, and defendant cannot win with wiggle. That's my point. The burden is upon him to demonstrate that his prior conviction did not include the dwelling element.
So I think what you're saying is that 6811 has to be read in conjunction with 6814, which we have now clarified that, and even in Bush, in Bush, that's where we use the word none. I mean, there was nothing in that statute that talked about a dwelling.
Correct.
There were no options. And that's why we said nothing. Okay, so that's where we interpreted the word, did not require proof of any of the circumstances. Okay,
Correct.
nothing. Okay, here we clearly have a divisible statute, so we've not ruled on that. But we also have 6814, which clearly the legislature wanted to address this. You know what? When you're sitting there at sentencing, you better raise an issue.
Yes.
Okay, but we're not going to cut you off if you don't.
Correct.
Okay, you've got the PSI, and if you don't raise the issue, then the PSI counts, and the judge, it says the criminal history shall be admitted by the offender or determined by a preponderance of the evidence by the judge, and that the PSI counts. That's enough. That's all you have to prove. Now, and then it talks about if you have a dispute about it, you got to go produce something that the state's got the burden. Okay. Now, if you want to bring it up here, you're allowed, fact finding. If you want to bring it up here, then the defendant has to show, when you have a modified divisible statute like this, modified categorical approach, divisible statute, then just show us the journal entry from Georgia.
Correct.
This is so clear that this is what the legislature wanted. Is that what you're saying?
That is what I'm saying. I think
What-
it is that simple.
What I'm struggling with is what would the journal entry show on this statute? Because it's all under one subsection.
Well, you can look at-
You don't usually see a journal entry talk about the facts that would differentiate which division of the statute you're under.
And that's the cite to my brief again to pages 12 and 13. We're not talking about facts. As a matter of law, prosecutors in Georgia from the very beginning are required as an element to allege the location where a burglary took place. And that, in most circumstances under Georgia law, it's going to be a dwelling.
So that's
We're
my
not
mistake,
talking
saying it's a
about-
journal entry. It
we're-
could be any kind of proof.
I was gonna say, we're not talking about the journal entry most likely. It would
Sorry.
be more like
That was my
what,
fault.
a complaint, assuming that's the word they attach to the charging document.
Yeah, a complaint, I think the list comes and it's been listed, but yeah, there are a number of different documents that a defendant could produce. We saw that in Steiner, where there was an attempt, at least, for the defense to produce some journal entries from Arkansas. Unfortunately, they just weren't clear enough to carry his burden of proof. With Georgia,
So what you're
it ought to
saying
be
is
really easy.
that's what you would have had to prove had all the defendants said at the sentencing hearing is, hey, I object.
Correct, we would
I
just,
object. That's all they would have said. I object. And then it would have been your burden of proof to produce whatever it is that was.
at the district court, correct. But now it's not, it's his burden. And
Can
he's
I-
done nothing to carry it.
A quick sort of textual question.
Sure.
In 6811, well, I guess it's big B3, the
Uh-huh.
provision we're all talking about,
Yeah.
the any element or any circumstances, provision. I want to draw your attention to the word offense. Is it significant at all, and does it impact your argument that the legislature chose the word offense there, elements of the offense, as opposed to what I think is the more natural and regular way of talking about elements as elements of the crime? Is there any difference between, and what I'm driving at is, can we read from that what the legislature is talking about here is the actual offense as opposed to the abstract crime?
Yes, That's exactly what I'm saying. The legislature intended to preserve the categorical, modified categorical approach. We're talking about a specific.
So you're just saying and I'm sorry to interrupt, but just
Yep.
real quick to clarify, your argument is that the plain language of subsection 3 supports your position because it clearly is referring to the particular offense as opposed to the general crime.
Correct. And I think it does it multiple ways by saying an out-of-state conviction or adjudication of a felony offense and does a felony offense again, and then they tried to be clear about that. There are no other questions. I know I've gone a little bit beyond time, but this is a topic we've all talked about a number of times. So I appreciate it. And I would simply ask the court to hold the defendant to his statutory burden at this point in time and to deny his claim. Thank you all.
May it please the court, Hope Faflick Reynolds, still on behalf of Mr. Daniels. I think what this comes down to is that Mr. Daniels cannot stipulate to a legal conclusion. And the question in this case is a legal question about how his prior conviction should be treated under Kansas sentencing law. It's something the legislature has struggled with. It's something this court has struggled with. It is something that the parties have struggled with. It is not something that he can stipulate to in court. And so we are asking this court to reverse his sentence and vacate it or remand it with instructions to reclassify the prior conviction.
But under 6814, with this whole burden of proof situation, couldn't you have submitted evidence up here? Doesn't that allow you to submit evidence up here? To show that it was not, did not include a dwelling?
Appellate rules allow adding journal entries. In this case, I don't know that the journal entry shows anything because, like Chief Justice pointed out, everything is under subsection A. I also don't think that it's necessary because this is a legal question based on the face of the statutes, the face of the Georgia burglary statute and its elements.
But it says that if the offender later challenges the offender's criminal history, the burden of proof shall shift to the offender to prove such offender's criminal history by a preponderance of the evidence.
Yes,
That's what the legislature said. And they changed that in 2021. This is a new language.
yes, and I would maybe back up and say that because it's a legal question, whether or not he had a Georgia burglary conviction is not the issue. Everybody agrees he was convicted of burglary in Georgia. The facts of that conviction are not necessarily, we argue, relevant to how Kansas law should classify that conviction.
So
for
you
his
don't believe the
score.
modified categorical approach exists after when the legislature, I don't remember what year it was, changed the whole 6811 bye-bye modified categorical approach?
I think that it doesn't exist in this case on these facts. I think I can imagine cases in which it would apply.
Why isn't this the perfect case with a divisible statute?
Because of the way the statute is written with the subsection. So I'm looking again at this court's opinion in Bush and how it treated the trespass statute versus the burglary statute from New
Those were
Jersey.
two different statutes.
Right,
This is a divisible statute.
right.
So again, to oversimplify, because I'm still struggling, I still think you guys are talking past each other. And I'm just trying to find a way to analyze this. Let's assume that Georgia burglary was in a house. You're saying that doesn't matter because we have to interpret the statute to say that because of the way the Georgia statute is written, this can never be a person felony.
That's correct, Your Honor.
Okay.
And can I just explore that precise question really quickly? And I really just want to hear your response to the exchange I had with State's Counsel at the end of his presentation with respect to the text of subsection little, 3I, I guess. And it's that question of is that subsection talking about the elements of the actual offense at issue, or is it talking about, because you're arguing, no, this is talking about just the elements of the crime, because as you said multiple times, we can just look at the face of the statute and that ends the discussion.
Yeah, so my interpretation would be that the word offense in little triple I refers back, is its antecedent is out-of-state felonies in little 1I. So offense is substituted for felonies. And when you read the statute as a whole, as this court has told us to do in statutory construction, I think that is clear. It's talking about an out-of-state felony or the offense.
The language of 2168-14D, I'm going to flip you back to that statute, has struck me as odd before. And this case is kind of underlining, I guess, a distinction that the legislature chose to make there. And this goes to the language that I think is their attempt to, how does an appellate court become a fact-finding court? And so they talked about allowing the defendant to supplement the record with a journal entry. But we've already talked about how in this kind of a case, the journal entry probably is not going to assist in the inquiry that we have to make. There's another sentence that allows the use of complaints, verdict forms, other documents, but that is limited to taking judicial notice of Kansas records. It doesn't impact, as I read it at least, on facially out-of-state convictions. Is there anything that we can discern from legislative intent there that they really are back under 6811 trying to make a distinction on those out-of-state convictions, that if we have to probe beyond the journal entry, we're not going to go there?
I think, and I will say in practice, the legislature's exclusion of that mechanism in subsection D tells us that it's not allowed. It's only judicial notice for in-state issues, and there's not a mechanism to add those other documents from out-of-state convictions to the record on appeal. When we have tried to, we have been met with objections from the state because the appellate rules and the Kansas statutes do not allow the addition of those documents. So that is something that the legislature has said no to, that this court's rules have said no to. And I think that we're without an option there, which tells us that the scope of what appellate courts can do in fact finding. Your Honor,
Or certainly that if we adopted the state's position, you would have been unable to make the proof that they are asking that you would have made.
That's right, Your Honor, which is another reason that we should decide this case on the face of the statutes.
So you're saying this requirement part of it just makes everything easier for everyone. It's just going to be a non-person felony if circumstance is not required in out-of-state statute.
Yes, Your Honor.
Two things. First of all, you didn't produce the journal entry, right? And it
No.
could have shown, right?
That's true. It could have.
Right. And second of all, so your position is that the legislature, if there's a statute in any of the other 49 states that talks about burglary, and it's the, there's 9 subsections on burglary, and every one of them includes a dwelling, and then the 9th one, though, doesn't mention dwelling. It was the intention of our legislature to say, oh, well, we don't want to count that.
Knowing our legislature, don't know that that is what they intended, but I think that is what the plain text of the statute they wrote requires.
And that is based on what?
Subsection little triple I.
And that is, and tell me exactly what language in there?
shall be classified as a non-person felony if the elements of the offense do not require proof of any of the circumstances listed in the above subsections.
Do not require,
Require proof, the word require,
require. So it's all based on the word require.
right, which is the word this court interpreted in Bush.
No, but in Bush is completely distinguishable because there was nothing in that statute. It wasn't a divisible statute. It didn't, in this statute, they talk about dwelling. I think they would say the word dwelling 3 times in this statute. There was no dwelling mentioned in the other statute.
Actually, what I understood, the criminal trespass was the only divisible one. And it had a misdemeanor component and a felony component. The felony component required residential presence, correct?
Right, and the PSI noted residential on it.
Right, but I was actually talking about not the trespass one, but the,
The other one, right, the other one had
Nothing.
nothing that required a residence, correct?
okay, thank you for allowing me extra time.
I see my time has expired. May I briefly conclude? We would ask that this court find that this is a legal classification, an issue of law, and remand the case for resentencing with instructions on how to properly classify the out-of-state prior conviction. Thank you.
Thank you to both counsel for your arguments today. The court will take this appeal under advisement. I will now call 124-878 State of Kansas versus Gerald Hambright.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state, and just to confirm, 3 minutes of rebuttal, Your Honor. Happily for me, this case does not involve a criminal history question. This does involve what I consider to be a unique scenario as far as what the actual issue is. And starting right off at the top, I will acknowledge that counsel is absolutely right in the cross petition that he filed, or perhaps it was in his response to my petition, that I did not, in the original brief to the Court of Appeals, I did not argue invited error with respect to issue 1. But that's because as the issue was briefed by the defendant in the original brief, he argued it as a straight sufficiency claim. However, it became apparent at the oral argument, and then even more so in the opinion that was filed by the Court of Appeals, that the panel was very clearly lumping together the actual sufficiency claim with the lack of a definition, be it a lack of a statutory definition or a lack of an instructional definition to give the jury guidance on what a dagger is. When you read that majority opinion, you will find very little analysis of the evidence itself, which would be the knife, the dagger, the object in this case. You will find multiple pages of analysis that involves definitions, pictures of daggers from various dictionaries, all sorts of things that have nothing to do with a straight sufficiency claim. And so because in my reading of that opinion, you simply can't look at that and say that this was a straight traditional sufficiency of the evidence reversal. Rather, it's a reversal that was based largely, I would say primarily, on the lack of an instruction telling a jury what a dagger is. And that's where you simply cannot ignore the fact that in this case, the state asked the court to give a definition, to guide the jury and say, this is what we are proposing you define a dagger is.
Let's go back to the issue the defendant argued of sufficiency. Was a definition necessary? Did the state make the choice when it shifted and amended its complaint to specify dagger after having the due process challenge to a broader the listing of the terms, was the approach then from the state going forward for the state that dagger is a common term that doesn't need definition?
It's an interesting question because obviously we did propose the definition. It was the state who suggested that the court give that. So perhaps it would be inconsistent for me to argue that the way that the state proceeded below, that the state felt that it was a term that would be commonly understood by a jury. But I don't know that the fact that the prosecutor asked the court to give a definition necessarily meant that the prosecutor felt that without it, it could not be established. I think
The
perhaps.
state, I'm sorry, I didn't mean to interrupt.
No, I was just wrapping up by saying, I think perhaps the prosecutor, and I don't want to speak for her, but perhaps she thought that it would just be additional clarity to alleviate any possible concerns. But to your question, as far as whether a dagger, the word dagger is a term that a juror could understand, I think clearly the legislature feels that it is, because otherwise they would have provided some sort of a statutory definition for it. And I think that's always, this case does, or this court does tell us that we presume that ordinary words have ordinary meanings and that jurors can understand them without being given specific additional legal definitions.
And I noticed that you chose not to have opinion evidence or expert testimony about this is how we would classify this.
Right, yes, it was the only witness in this entire case was the officer.
I assume the state's position is that that's not necessary, that from the circumstances of the appearance of the object, the jury could conclude it was a dagger, as I assume what the state's theory of the case would be.
I believe so, and I think that is logical, that a jury, a common juror, a reasonable person could look at the item, which they had the object itself, plus all of the pictures that helped give them additional guidance as far as the dimensions of both the blade and the handle. And I think a common juror would be able to look at that and have an understanding and differentiate, okay, is this a dagger or is it, I know in the majority's opinion, they point to things like a kitchen knife or a letter opener or various other objects. And my position is that yes, a common person is going to be able to look at an item. And I think, again, when you look at the object in this particular case, and I know the pictures are in the record, and counsel and I both have copies of them as well. I think very clearly a person could look at that and see how that is distinguishable from something like a butter knife or a letter opener, or even, some sorts of common pocket knives. Pardon me?
A chef's knife? I mean, we're not trying to prevent these defendants from being able to cook vegetables, are we?
Right, and I think that, again, as I look at this item, and I will acknowledge that I'm not the most handy person in the kitchen, so I sometimes have a hard time visualizing this particular types of knives that are used in cooking. But as I look at this particular blade, my belief is that a reasonable juror looking at this and having the evidence in front of it would be able to distinguish and realize that that is an object that, quite frankly, I have a hard time thinking that anybody would possess that type of an item to do anything other than stab, inflict some sort of injury on, and I know the argument could be made, well, perhaps this is similar to a hunting knife. Well, again, hunting knives are intended to inflict damage. What do you use a hunting knife for? You use it to either wound an animal, or after the animal has already been killed, presumably, to then gut the animal. This is not something that would be used similar to for cooking. I don't think anybody could look at this and say, yeah, this is something where there's any reasonable argument to be made that this person is using it to spread butter on a roll or cut a piece of meat or anything else.
Well,
But
this person, there's some indication this person may have been homeless.
correct.
So if you can only have one knife to do everything, this knife be it? Cook vegetables to, trim twigs for a fire to, I mean, there's another side to this knife too that has of some purpose. I'm not sure what.
But I think as we get into that analysis, then we're deviating from what we should be looking at if it's truly a strict sufficiency of the evidence argument. And I think that's one of the things that Judge Klein pointed out in her dissent, is that the majority seems to be trying to almost compare this evidence to what could be considered an ideal case, where you've got the perfect evidence, where you have an expert who's come in and said, this is exactly what a dagger means, and here's my qualifications on how to tell you that. But that's not, in a sufficiency context on appeal, that's not what we're supposed to be focused on, is coming up with potential hypotheticals or saying, could a jury have interpreted differently? If the jury had looked at this and decided that it was not a dagger, they would have acquitted him. And as the state, we would have had to have lived with that verdict. That's a decision that's up to them to make. But they saw the knife, they saw the pictures of the knife, and they determined that this was in fact a dagger. And again, I think when you look at this particular object, you see a very sharp pointed blade. I would note, much like Judge Klein did, I think that the majority, first of all, I think they were incorrect in using the definition and then saying, well, generally speaking, these definitions seem to refer to blades or edges, plural. I think fewer than half of the definitions that the majority itself used actually referred to blades or edges, plural. But as I look at this picture,
So is the test then whether it can be used for stabbing? Is that the only test for this sufficiency?
I think that to the extent that there needs to be a definition, a specific definition, I agree with that definition that Justice Biles proposed in the dissent in Harris, and that Judge Klein would have used in this case as well, which is, yeah, a short pointed blade used for stabbing. And that is consistent with the dictionary definition, I believe it was from Webster's. And again, I know that the majority went back and came up with 12 dictionary definitions, some of which dated back, I think, as far as the 60s.
Counsel,
Straight razor fit that. I mean, that, because the statute says a definition of a knife includes a straight razor.
Yeah, there's the dagger, dirk, stiletto, straight razor.
I understood you to be saying that the definition you're providing is the definition of a dagger. As opposed to.
Yes.
So I guess my question is, why do we need definition? I mean, it's like the old saying that it becomes turtles all the way down. Like, why not provide a definition of stab?
No, right.
Why not provide a definition of sharp or point?
Exactly.
Why isn't this just an ordinary English word that we entrust to jurors in their common understanding?
No, I appreciate that question, and I want to clarify. I think I agree with that position. My point is that either way we win. This is either something which I believe primarily that this is a common word that a common juror would understand that does not need a specific legal definition. Secondarily, I would argue that if this court does think that a definition is needed, it should be the definition that Justice Biles used in Harris from the dictionary and that Judge Klein used in this case. And that even under that definition, if it's necessary, the state would still prevail in this particular case when you look at the evidence. But what I take issue with the majority opinion primarily is where they are so focused on the lack of a definition and saying that then creates a lack of sufficient evidence, when in this case, to the extent that a definition is needed, it was the defendant who adamantly objected to that being given to the jury. And so on appeal, even though he wasn't the one who initially framed it as an instructional issue, he shouldn't be able to prevail based on the lack of instructional guidance to the jury. I'd also note another issue that I take with the majority's opinion is that I don't understand why they even addressed the residual clause in this case. The residual clause was a non-factor. It was not instructed upon. The jury had no way of knowing it ever existed unless they are reading Kansas statutes as a hobby. They have absolutely no idea that there's a residual clause in the statute. So that is kind of a non-starter as far as why that would even be discussed. So again, yes, to clarify, our primary position is that this, like thousands of other words that are included in elements of crimes or in jury instructions, it's a common word with a common meaning that a reasonable person can understand, and that under that test, we met the sufficiency of the evidence. But secondarily, if this court were to decide, like the majority, that a definition is needed, it should be the definition from Harris, from the dissent, and that under that definition, the state also provided sufficient evidence that this object met that definition and therefore supported the conviction.
I ask, you're suggesting that the instructional error was invited, right?
Correct.
What, if that is true, what impact would that have on the prosecutorial error argument, which sort of picks up where that instructional error leaves off, where the prosecutor then is arguing based on the instruction, an expanded definition of what constitutes a knife beyond the charging document?
Yeah, and that's why I think like so many, or like all prosecutorial error claims, you have to look at the totality of the closing argument. And when you do that, you'll see that while the prosecutor did mention that definition, that included things like the dirk and stiletto and straight edge, she very quickly followed it up and made very clear throughout closing argument that the question in this particular case is whether this is a dagger, and even told the jury, is it a dagger? That's for you to decide.
I guess my question was more like, if it is invited error, then does that sort of give the prosecutor a free pass then for making that type of argument for an instruction that was invited?
Yeah, to the
into
extent that,
proceedings?
yeah, to the extent that this is the definition, or that this is the instruction that the defense wanted to then argue that the prosecutor stepped outside the bounds of fair argument and then, essentially parroting that language to the jury. Absolutely. I think that too is kind of an inconsistent position taken by the defense. But yeah, more broadly, my position is that when you look at that argument as a whole, she made very clear that in this case, what we were alleging is that this is a dagger of those 5 things enumerated, that we're arguing that this is a dagger and that ultimately it was up to the jury to decide. And the defense attorney also very clearly recognized in this case that that was the particular object or term at issue. So there's no chance that any juror was confused as to what they were being asked to determine in this case. I'm past my time. I will reserve the remaining comments for rebuttal, if any. Thank you.
May it please the court, Gerald Hambright appears through counsel Casper Shire, Kansas Appellate Defender. Gerald defended this case on a theory that State v. Harris does not allow a business as usual approach to prosecutions for criminal possession of a knife. The state had to amend its charging document to avoid getting its case dismissed, and that can't be a purely cosmetic change. It has to come along with some requirement that the state present evidence that the blade Gerald possessed was in fact a dagger and not just some other object that all of us would call in everyday speech a knife. They didn't do that. Nobody at trial said the word dagger until after the close of evidence. The first time it came up was in the defense motion for judgment of acquittal.
Well, I mean, in closing, the prosecutor said, is this a dagger? That's for you to decide.
And that is argument, Your Honor. It's not evidence.
But the pictures were admitted into evidence, and was the object itself admitted?
It was. It was.
So that's evidence.
That is evidence. But the state had a burden not just to, let me analogize this to a drug prosecution, Your Honor. We've got a white powder. I can put a witness on the stand. He can describe that white powder. He can tell the jury what it is. He can show the jury can put their hands in it if they want to, but they still have to have some evidence that that white powder is cocaine.
Does your argument depend on that analogy? In other words, it strikes me that you're saying that whether an object is a dagger or not is outside the scope of the common knowledge and understanding of it. In the same way that whether powder is cocaine is outside the scope.
Yes, I am saying that,
If that's not true, then you can't prevail.
well, the problem is nobody gave this jury evidence that this is a dagger. It didn't happen.
So you're saying there has to be direct evidence?
No, there doesn't.
Circumstantial evidence doesn't work? Or-
No, I'm not saying that, Your Honor. And
Well,
again, I think that.
And this isn't even circumstantial evidence. It is direct evidence. It strikes me what you're saying is that what's required is opinion testimony, whether lay or expert. I mean, somebody has to get on the stand and say, this is a dagger.
No, I don't think that's true, Your Honor. I think, for example, one way you could put on evidence that this is a dagger is, any company selling knives has a website now. They're marketing their knives. If a particular blade is marketed as a dagger, that's fairly good evidence that it's a dagger, whether or not you have an expert testify or not. So there are ways the state could have put on this evidence. They didn't do it.
Would it be the same thing if it was a switchblade? Would you have to, if there was a switchblade introduced into evidence, would you have to go on a website and do the same thing, or a straight-edged razor?
Yes, I think you would have to present some evidence that this, post-Harris, it can't just be that it feels like the right kind of knife. That can't be the analysis that we're doing anymore. There has to be evidence that this particular blade falls into this specific subcategory of knives that the legislature has designated as criminal.
I just struggle to understand why, when you put the object in front of the jury, that's not evidence. That's the disconnect that I sort of am struggling with your argument.
It's evidence of the dimensions of the blade. We know how long it is. We know it's sharp on one side. We know it has a serrated
Why isn't it
spine.
just evidence for what it is?
The same reason that,
Again, it depends on your cocaine analogy, which I understand.
well,
That you're saying that whether an object is a dagger falls outside the scope of the ordinary understanding and knowledge of a juror.
I guess I'm going to do what my opposing counsel did and say, yes, I agree with that this is outside the scope. I am making that argument. But separate and apart from that, I think there has to be some evidence, even if if the officer had said, look, I've seen a lot of knives in my day and this is a dagger, that is at least some evidence. What's that's based on? I don't know. And I think, maybe we get into, whether he's qualified to testify as an expert on that subject at that point. That never came up because that evidence never even got put to the jury. So we.
But once,
Sorry, just one second, just as well. If the statute said it's unlawful for a convicted felon to possess a cat, and the state came forward and said, we caught this guy with a cat, and here's some pictures, and here's the cat.
Right.
And a juror make a determination without any other evidence whether or not this defendant, in my absurd hypothetical, possessed a cat.
And I guess this goes back to the first point that we were talking about, is that I don't think daggers are like cats. I think daggers are more like cocaine than they
cocaine.
are like cats.
So it's that spectrum that we're discussing.
We are, yeah, obviously we're arguing about where this falls on that spectrum, and I think
That's helpful, thank you.
And so, no, I think my question probably is answered by your response, but then essentially then, once you have a definition, then that evidence would have been sufficient. Really, I'm trying to nail it down. It really is the absence of a definition that's the problem here, because had a dagger been defined and the jury is shown the actual object in question, it seems like that would have been enough. So really, it's the absence of the definition that is the basis of the argument, right?
No, I don't, I see the sufficiency argument and the instructional argument as two different arguments. And I would love to be here making the
So you
instructional.
would have said, even in the absence of a definition, as long as somebody would have said, this object you see is a dagger, that's what would have pushed it across the line.
I think unobjected to, that would have been enough to push it across the line, yes. If I'm defense counsel in that situation, I'm objecting, I'm at least trying to get whoever is saying this, testing their qualifications as an expert. Because I think if the Court of Appeals opinion teaches us one thing, it's that figuring out what exactly a dagger is not the easiest task in the world.
An expert to define that this is indeed a dagger, but not to define what a dagger is, right? Because that would be the legal question.
That would be a legal question, but yes, an expert certainly could testify, hey, these are the characteristics of this particular blade that make it dagger-like, right? And that's what's missing at trial.
So in other words, your hypothetical about having a website show that this is a dagger, you would have objected to that too, because that's not.
I may have objected to it. I don't, whether or not that objection is valid is of course up to the district court to decide. I'm not sure I could win that objection, because that would be not direct evidence that it's a dagger, but at least circumstantial evidence that it is. I mean, it's.
So going forward in every case under this statute, we're going to have an expert.
I don't think that's a bright line rule, but I think drug cases are a good analogy. Does the state plan on having a KBI chemist at every drug case that they're going to prosecute? I believe they do. And I think that would certainly be best practice moving forward, Your Honor.
There's no such thing as I know it when I see it in this world of a knife.
I don't think there is, Your Honor, and I think Harris forecloses that. Because the whole point of Harris was to prevent this standardless sweep, not yes from police officers, yes from prosecutors, but also from juries, is deciding, this particular knife feels like the kind of knife that ought to be
I just
criminal to me.
don't see the application of Harris, I guess, because it dealt with the residual clause.
It did deal with the residual clause, Your Honor. But looking at the big picture.
I mean, you haven't raised a vagueness challenge to the word dagger.
No, we have not.
And Harris was a vagueness challenge.
Yes.
And so I guess I'm just not connecting the dots in the same way. I would like to hear how you connect the dots, I guess, is the way to ask the question.
Sure. I want to emphasize a couple of things. First of all, this case didn't get charged for about a year after Gerald accepted a ride into town and turned over his blade, his knife, whatever you want to call it. He sits in jail for about 600 days, or some of it is Larned, but he's in custody for about 600 days. Much of it after Harris comes down. All of that time, he's charged under the residual clause. Then 4 days before trial, the state amends its complaint and says, okay, not the residual clause, dagger. And then essentially trots out the same prosecution that it would have rolled out to prosecute under the residual clause, with no evidence that this is, in fact, the type of knife that checks the boxes to be a dagger. So, big picture, I think Harris is important because this whole prosecution is the state trying to get around Harris. And they shouldn't be allowed to do that just by changing one word in the charging document. There has to be some change to their substance of their case, and there wasn't.
What do you think the significance is that knife in the statute isn't defined by anything that I would like classically refer to as a knife? I mean, it doesn't refer to a paring knife or a chef's knife or those, you know, something that would be readily understood to be a particular type of knife.
Right. And I think part of the problem there, Your Honor, is that the legislature has never come back to look at the statute again after the residual clause was struck down in Harris, because it did have a much broader sweep pre-Harris, certainly.
That have significance here?
I think it does, because if the legislature wants to, you know, daggers, dirch, switchblades, stilettos, straight edge razors, these are very, very specific technical kinds of knives. And if the legislature wants to amend the statute to allow, you know, prosecutions for more general, you know, long knives or double-sided knives or, you know, more general categories of knives, they certainly could, and they haven't, at least to this point. And I think unless and until they do, the state needs to present evidence that the blade they're prosecuting falls into one of the strictly defined boxes that the legislature has laid out.
It just strikes me that the error that I'm hearing from your argument is that what it takes to check those boxes to be a stiletto, dirt, dagger aren't within the realm of common understanding. And they have to be spelled out, which means that's a legal question, whether they should have been defined. But if that is true, is that the argument you're making in this appeal? I mean, has that issue, it's really not the sufficiency, it's really more about an instructional problem, isn't it?
I still think it's both, Your Honor. I think I'll be clear, I think an instruction would have gone a long way. In fact, I think Gerald's jury would have acquitted him if they had been instructed that a dagger is a knife that's used for stabbing, because there's absolutely no evidence that this knife was or that it's designed for that. But I still go back to the evidence. The evidence wasn't there. Even if they had been instructed, even if they'd been given, you know, the definitions that the state asked for, I would still be arguing sufficiency because there was no evidence to support the definition that the state asked for, that this knife could be classified under the definition that the state asked for.
But without that definition, how is that testimony carry any weight with a jury? I mean, somebody says it's a dagger, but we don't know what a dagger is. You know what I mean? It's.
I understand, but again, I come back to, I think the jury should have been instructed. I do not think defense counsel should have been objecting to that instruction. Maybe they should have been offering one of their own. You know, maybe we should have been arguing about competing instructions. But the district court should have instructed on some definition of dagger here. I think it was a mistake not to. And whatever definition of dagger you settle on and give to the jury, it's argument that there's still no evidence that would conform, that would show that this particular blade fits into the box.
I just point of clarification. You said part of the state's burden would have been to show that it's used for stabbing, and I might have misheard you, but this is a possession crime. It's not, if we just take it out of the category of a knife, if it's a firearm, there might be a possession of a firearm, but no showing that he intended to shoot somebody or even fire the weapon. So is that really a part of what we're looking at, how he was going to? I don't think it is, but just help me
No,
with that.
I don't, Your Honor, and I see I'm out of time. But if I could at least get through this one, Your Honor. I don't think how Gerald intended to use it had any bearing on whether or not it was a dagger or not. But I think the way it's designed, you know, nobody uses a double-edged stiletto without a blade guard to chop vegetables, right? The only reason we have knives like that are for self-defense or debatably self-offense, right? Gerald's knife was not that kind of knife. As I think Justice Wilson pointed out earlier, this is a knife that could be used for any number of things beyond stabbing, which, you know, maybe.
Sorry to interrupt, but real quick, it sounds that at least in part your argument is this isn't a dagger.
Yes.
That in fact, whatever the evidence was, no reasonable juror, even using their common understanding, could have come to the conclusion that this was a dagger.
Right. This is a utility knife.
The way I framed it is slightly different from the sufficiency claim. I mean, it's sort of it is sufficiency, but you were sort of camping out on no evidence side of things, whereas it seems to me now you're transitioning to, well, whatever the evidence was, this isn't it. This jury reached a conclusion that just simply cannot be supportable because this is not a dagger.
I appreciate that I'm mixing those two somewhat distinct concepts, but I think it's difficult to unravel them sometimes. I think some mixing is inevitable.
Questions? Anything else you'd like to add in closing?
We would simply ask this court to affirm the Court of Appeals and to vacate Gerald's conviction.
May it please the court. Just to pick up a few key points here, and I think I'll probably be the first person in history to make this particular statement. Yes, I would argue that daggers are more like cats than cocaine. I think that there is a much greater common understanding among a common person about dagger than there would be about the ingredients of cocaine or any particular drug.
Counsel, if that's true, why was this not charged originally as possession of a dagger?
Well, I think it was charged originally. It was before Harris. So this was charged when the residual clause
Right,
was
but if it's
still
so
valid.
obvious that it's like a cat, there's some resonance that the defense counsel's argument has some resonance that, look, for 2 years, however many days, 600 days, whatever, charge was under the residual clause. And now you switch it because of Harris. But
Well, it wasn't
if you
ju-
really thought it was a dagger from the get-go, why didn't you charge it that way?
It wasn't just charged under the residual. I think it was originally charged under all of I think it included Dirk Dagger, and then the record will speak for itself. But I think just in general, I know as the appellate division, we always tell our charging attorneys and our prosecutors to, err on the side of starting broad and then narrow. if you start narrow and go the other direction, then you're creating all kinds of problems. And so we generally tell them, look, you don't have to narrow it down in the complaint. You can keep it, we always try and tell them, keep the to wit language out of the original charging document, because you never know how the evidence is actually going to play out. And so I think that's generally the answer to that question in a broader perspective. But
But then maybe beyond that, why ask for a definition if it's more like cats?
right, and again, I don't think she had to do that. I think she was probably just trying to cover all the bases, and maybe having read Harris and having been aware of that case, was just thinking to herself that out of an abundance of caution, let's give the jury some guidance on that. But I do think that was an unnecessary step that she took. Because again, I do feel like this is more like the cat analogy. And to the Chief Justice's point, I think it is one of these situations where you know it when you see it. And I think that sometimes when you try to define an object like that, then it creates additional problems. And to Justice Stiegel's question to me originally, then, okay, let's say you define it as an object that is pointed and used for stabbing. Then do you then have to decide or define what is pointed? Is there a certain parameter that has to fit within then? And what does stabbing mean? So I think at some point you just have to trust jurors to understand and be able to make that determination. I would say that as the cocaine analogy was being discussed, one thought that I had is, if there is a case where somebody is charged with possessing cocaine and the state does not put on an expert to testify about lab results showing that it was in fact cocaine, you just put the bag of cocaine into evidence, you let the jurors see it. If we don't put on that lab result, we're probably not going to get past a jury as far as getting a conviction. But if we do, if the jury looks at that and they determine that that's sufficient evidence, whether you can determine that circumstantial evidence or direct, however you want to refer to it, it's evidence of a white substance, and let's say it's in a baggie packaged the way that cocaine usually is. If the jury looks at that and they determine that it is cocaine and they convict on appeal, I don't think we lose that case. I think that there's judged against a sufficiency of the evidence standard, light most favorable to the state, look only for evidence that supports the verdict, don't search for contrary results or other interpretations of the evidence. I think that even in that case, there's a strong argument to be made that that would withstand a sufficiency. Now, again, I'm not saying that we would be likely to get the jury to convict, and clearly a good defense attorney would point out the lack of test results to the jury. But if the jury convicts in that case, I think that even using the cocaine analogy, when you have the evidence itself, and Justice Stiegel made a point that I made in the brief, and I certainly stressed this at the oral argument, the defense is focusing on the lack of an officer or somebody coming in and using the word dagger and acting like that would be the gold standard. I would argue that the actual object itself, shown to the jury, they can pass it around the jury room, they can inspect it, they can touch it, they can hold it, they can do whatever they want with it. I would argue that that and the pictures is the strongest evidence you can get. It's the actual object, and then they can look at it and they can determine. And one final point, just to pick up with a question that Justice Wilson asked, noting that the statute does not refer to things that would be common, kitchen knives or cooking knives or things of that nature. I think that's telling in that it shows that this is limited to objects that are clearly designed for purposes that are not common kitchen uses or pocket knife uses. You're talking about all of these objects are things that the general usage is to inflict damage on another living being. For
Well, are those things mutually exclusive then? If I find this is a utility knife. It's not a dagger. It's not I had to look up dirk, frankly.
We're in the same boat there.
So are they mutually exclusive?
I could certainly see some items where there would be overlap. I'm far from an expert. I'm not a hunter, so I don't really know the ins and outs. I'm sure there are multi-purpose knives that could, one person might use it primarily or exclusively for a utility purpose, while another person uses it for violence against another person. So I don't know that I want to commit one way or the other to saying that they're mutually exclusive. But again, we're looking at the knife in this particular case. And as I view that knife, I think perhaps just a common sense way to look at it, which again, keeping with a common understanding of the word, if I see somebody holding a butter knife, my instinct is not to be fearful for my own safety. I'm not worried that that's an object that is used for stabbing. If I see somebody holding that knife near me, I'm certainly going to have a lot of reservations, because that is certainly a sharp pointed knife or blade that in its common use could be used for stabbing. So I know I've made a lot of alternative arguments there, but I think that just highlights that regardless of whether you feel a definition is or is not necessary, under any of those scenarios, our position is that the state should prevail in this case. Thank you for allowing me to go past my time. And if there are no further questions, we would respectfully ask that this court reverse the Court of Appeals and reinstate the defendant's conviction.
I see no questions. Thank you.
Thank you.
Thank you to both counsel for your arguments. The court will take this appeal under advisement, and the court will be in recess until 10:50.
Rise.